The Criminal Law Handbook by Paul Bergman and Sarah J. Berman. This book takes you through the entire criminal justice process. The authors use a question and answer format and breaks down each aspect of the law. If you were to read this book and understand everything thoroughly, you'd have a really good chance of surviving the American legal system. In this video, I'm going to give you 10 things that most people don't know about the law that are talked about in this book. 1. Police can lie during interrogations. Police can say anything to get a confession. They can lie, deceive, claim they have evidence when they don't. This is why you should never talk to the police. Demand a lawyer and shut up. 2. Miranda rights aren't always required. Police don't have to read Miranda rights unless a suspect is in custody and being interrogated. If you aren't under arrest or being questioned, they don't have to read those rights. In case you don't know what the Miranda warning is, it's when a police officer says you have the right to remain silent, anything you say can and will be used against you in a court of law, and so forth. You can look it up. 3. Prosecutors have broad discretion. They can decide whether to charge someone with a crime, what charges to bring, whether to offer plea deals, and how to prioritize cases. This happened during the Antifa and BLM riots. Many of the rioters were released from police custody and never charged. 4. Preliminary hearings are mini trials. At these trials, a judge determines if there's enough evidence for a case to proceed. These resemble mini trials with witnesses testifying and evidence being presented. If the judge finds probable cause, the case will proceed. 5. Bail isn't always cash. Bail can sometimes be posted through property bonds or release on recognizance, meaning no payment at all. 6. Plea bargains dominate. Over 90% of criminal cases never make it to trial. They end in the plea bargain stage. Courtroom dramas make it seem like all cases somehow make it to trial and it's dramatic, and that's just very rare. 7. Right to a speedy trial isn't absolute. Speedy can depend on jurisdiction, complexity of the case, availability of witnesses or evidence, court scheduling conflicts, and defense requests for continuances. 8. Victims have limited control. Victims have little say in whether charges are pursued or dropped. The decision rests with prosecutors, not victims. 9. Juvenile records aren't always sealed. Contrary to popular belief, juvie records may not be automatically sealed and can impact future opportunities if not properly addressed. 10. Appeals are narrow in scope. These typically focus on reviewing legal errors that may have occurred at trial, such as improper jury instructions, incorrect application of law, evidentiary errors, and constitutional violations. This is a book you should read whether you are a law student or not.